My name's Lauren Harris. I'm a research assistant on the Property, Family and Trust Law team on the Wills Project, and I'm now going to talk to you about legal writing. So you have heard from Clara about how you can conduct and approach research ahead of writing a dissertation. Now we're going to look at how to implement that research into your writing. So first of all, starting with a few overarching tips. The first of it is having a strong central argument. It's really important to be clear before you embark on your writing what narrative you want to create, what argument you want to create and inform the reader of in your writing. This requires a really good understanding of your area and of your kind of research that you've already conducted. The second tip is treating the dissertation as a series of linked essays. So each section can work as a self-contained essay that argues a particular point relevant to the overarching essay topic and central argument. This is a really good tip for two reasons. First of all, it just helps you kind of break down what can be quite a large piece of writing. And second of all, in breaking down that writing into separate essays, you can start narrowing your argument and structuring your argument in a way that builds on one section to another. But if you're going to use this approach, remember to make sure that each section is linked and that it follows on to the next in order to ensure that the essay flows and that it works as a coherent whole. Even though these sections might be essentially separate essays, they should all be sitting under your strong central argument, and establishing links between those essays will really help to build and support that argument. So the third overarching tip is making sure that the essay is structured in a logical and coherent way, and we're going to see in a few slides how you might go about structuring it. And also using sections, subsections, and subsections. I find it can be quite helpful to start thinking before you begin writing, having a rough draft of what those sections, subsections, subsections might be, what kind of arguments you might be discussing there. And the way you can do that is using the headings feature on Microsoft Word to almost create draft little headings for these sections. And those headings can really be the point. So what point are you making in this section? What point are you making in the subsection, etc.? And then having a look as though it's almost a contents list for your dissertation, seeing, do all of these points flow together? Are all these points relating to my strong central argument? And having that document there as you start your writing and checking against it. So if you approach a piece of writing on one section of your dissertation, checking, have I stuck to the point that I want this section to be giving? Have I stuck to this specific piece of narrative that supports my central argument? Okay, there's three kind of main aspects of a piece of writing. So starting with an introduction. A good introduction will impress the reader from the outset. How might you go about doing this? Well, you can provide context, or you should provide context to the question and the legal issue. You should state why your research or your area of law is important. You should define any key terms and concepts. Now, what can be quite a useful thing for yourself to think about is, as you're writing, noting down any terms that keep cropping up or any concepts that are kind of defined in a particular way in the reading or in your own piece of writing that you think will need to be defined in the introduction. So making a list of those as you go through. When it comes to your introduction, or when you come and return to your introduction that's already been written, you can have a look and see what these terms are, and then define them. And defining these terms is really important because it enables the reader to be able to really engage with your argument and know almost the building blocks of the argument first in order to really get to grips with what you are writing about. And also you should be stating your argument clearly from the outset. So don't keep the reader guessing. It's not a murder mystery. You want to be really clear about what you think about this topic and what argument you're going to be making. You also want to be clear in what section of the dissertation you'll be making what argument. So again, going back to that list you have of the different sections and the different points that you are going to be making, which will ultimately build up to your overarching conclusion based on the issue. Be succinct, focus on the key themes and the arguments, and don't reproduce every detail of the main text in the introduction. So you want to be clear of the skeleton, the main part of your argument, but you don't need to give away how you are reaching the conclusion. That can come across within your argument as it builds. But the reader should be knowing, okay, this is where certain argument is going to be made. So almost a general signpost about how you are going to reach those conclusions without giving everything away. Okay, then second of all, we have the body paragraphs. This is where you're going to be arguing a particular view, bringing in primary and secondary sources and evidence to support this view, critically analysing the sources, which is really important. And also a way that you analyse these sources is by addressing potential counter-arguments. And finally, having sentences that link sections to the essay together so the dissertation flows as a coherent whole. And then the conclusion. So in the conclusion, you want to be summarising and restating the central argument and the points made. You don't want to be introducing new points or arguments in the conclusion. You don't want any nasty surprises for the reader to kind of grapple with in the conclusion. You want to just be tying up everything that has already been said. But you do want to end on a more general forward-looking note concerning the area of law in question. So it might mean that you're having to balance and assess if you're making a forward-looking comment, making sure that you're talking about something within the context of what you have written and you're not introducing a new point or a new argument that doesn't relate to the arguments you have already made. Okay, so moving on to an example of a good introduction. In a second, I'll ask that you pause this PowerPoint so you can have a read of this example. But just to introduce it, this is a fairly short introduction that is placed in a chapter midway through an edited volume. It is indicative of the features of an introduction, but it is not a comprehensive account of a dissertation introduction. This is just basically a good example for you to be able to identify 4 key aspects of an introduction. So the context and the statement of significance, defining the scope of the essay, what will and what won't be covered and why, and the central argument and objective of the essay, and then defining any key terms. A student dissertation should also signpost what is to come, which this example doesn't necessarily do so much, but in your dissertation you're going to want to be aiming for around 10% of your total essay word count in your introduction. So it's an opportunity to provide more context, more background and commentary regarding the significance of the legal issue in question, and then signposting in what section you will be making what point. A student dissertation will likely have a stronger and more blatant central argument than this book chapter, which is partly explanatory, as I've explained. So I invite you to have a pause, and then we are then going to move on to considering the body of an essay. So moving on now to considering how to approach the body of the essay. So I've already said about structure, making sure that there's logical and coherent sections and subsections. You can see on the left here an example of how you might take an introduction like the one you've just looked at, and then create an argument using these types of subsections. So you can see here it starts with an introduction, then the question, subsection 2, what is a DRT, then mitigation of risk, then the nature of the legal relationship. And it's at this point that 2 subsections are made. contrast with the intermediated system, and possession. So here it's quite clear there's two aspects that the writer wants to talk about: the nature of the legal relationship, and they've used that and signposted it to the reader by introducing two subsections instead of a new section. The same can be said about the section, the cross-border conundrum, issues of private international law. Here, the writer's broken down the argument and their argument about the issues into three aspects. So the challenges, then potential approaches to resolving the conflict of laws, and then location of the private key as a connecting factor. This is because these, as you can see, subsections fall better under the umbrella of a section rather than as their own section. And then you have a conclusion. So, for example, if you were approaching your piece of writing, you had this as a planned kind of piece of content list, then you could use this list and check against what you're writing. So if you begin with your first almost mini essay, what is a DLT? When you go back to look at that piece of writing, you can check thinking, have I explained to the reader what is a DLT? Have I ticked that kind of intention that I've had? Have I met what I wanted to originally talk about in my planning? And that's a good way of checking whether you have kind of stuck to your overarching argument and built on your argument as you intended to do. This can change though. You can go back and edit, you can change, you can move things around once the writing starts to take form. So don't feel restricted by the piece of structure that you've chosen. So another aspect is critical analysis, thoroughly evaluating material and the significance of the sources cited, using evidence convincingly to support the argument, directing the material to support your argument, zooming in on the controversial aspects of the topic in question. This point is really important because you should not try to shy away, and we'll go on to this later, but shying away from controversial aspects in the topic. If you are able to effectively engage with these controversial aspects and identify them and then engage with them and then apply them to your argument, that really shows that you've got a very high level understanding of a topic, because often legal issues, they don't exist in a vacuum. There will be controversial aspects of them, and you want to show confidence in your writing that you can engage with these aspects. Then demonstrating an understanding of trends and patterns in the literature and showing an understanding of different forms of critique to the sources and area of law. So generally in the literature, there will be trends and patterns, such as there might be a body of academics who kind of generally agree, there might be some who disagree, but within that kind of division, you will have subsets of approaches, of kind of theoretical approaches to a certain legal issue or approaches and opinions. There might also be trends and patterns in terms of when these opinions were being given. Are there is there a group of academics who have kind of critiqued this particular legal issue? If so, when were they critiquing this issue? Does that compare in terms of time to the body of academics who agree with the legal point you're discussing? Is there a significance there in the fact that the criticisms come before there might have been other developments in the law, for example? So trying to identify, grouping together your research and your readings based on these trends and patterns can help you to kind of balance these ideas and linking them to your central argument in terms of which ones support them, but also why might these arguments support them. Finally, we've got control. So trying to demonstrate control in your essay. What does control look like? Well, it can be achieved by demonstrating a strong understanding of the area of law in question. So showing that you have confidence to talk about the challenging parts of the area of law. Providing high levels of detail, so not shying away from these complex aspects, but also making sure that when you're discussing this detail, you're assessing these bits of detail with accuracy. So confidence and accuracy need to be considered. You don't want to be completely kind of confident in what you're writing without having properly checked and considered all of your resources. And that's how you show control, is by balancing those aspects. Demonstrating depth in analysis. So this means being selective about what you cover and what is most relevant to your essay. And this requires good judgment. And then being able to analyze this material in depth. So not everything that you have come up in your research will be relevant. There might be things that you think are no longer relevant to your argument, but you might have still spent a long time researching them, and it can be tempting to almost find a place for these bits of writing or for these arguments within your dissertation. But a reader will be able to identify where you are using evidence that doesn't really have a place or doesn't really do much for your argument. So try to resist the temptation of including things that don't necessarily no longer fit in your writing. And then accurately categorizing and defining views. So if a group of academics seem to be arguing the same thing, you could categorize and define this view. So you can make up, well, not necessarily make up, but you can define and categorize using certain terms that you decide. So for example, the pro-DLT mitigation view. Giving a name to a view or giving a name to a trend or an argument can really help kind of narrow down what is being said and kind of categorize and assist the reader in understanding the different parts of the issue. Now we're going to consider nuance, and nuance is really important for legal writing. All essays should aim to, as I've said, present a strong central argument, but also to critically analyze sources. And arguing and analysing with a degree of nuance will elevate the essay further and elevate these two essential aims. A top tip for nuance is that often when reading secondary sources, you will come across statements and perspectives which reveal that the legal issue you are addressing is actually more complex than you initially thought. Students achieving lower grades will ignore and attempt to bypass this newly revealed complexity. Higher achieving students will dive into this complexity and the uncertainties it presents, taking account of it in their argument and in their analysis. So let's have a look now at three kind of approaches that can be categorized as poor, good, and excellent in regards to how they approach this tip and this idea of incorporating nuance into your writing. So first of all, a poor approach. A poor approach is where the writer provides a purely descriptive account of the area of law. This means that the writer does not present any central argument. Where arguments from secondary sources are cited, the writer fence sits and does not indicate a preference between views. It's really important that even where there are two sides to a particular issue or topic, you try to make a decision or try to reflect yourself on what you think about that particular argument and then present that in your writing. Just because an issue might have a kind of opposing argument doesn't mean that you can't, decide that you agree contrary to that oppositional view. As long as you justify and you provide relevant sources and you engage with that kind of opposition, then you can move forward with your argument. And that's a lot better than kind of fence sitting. And you might not be sure how you actually view these arguments or what your position might be. And I would say to kind of approach this issue is just trying to sit with your research, sit with your understanding of the writing, go on a long walk or kind of doing your normal mundane tasks, having a walk, maybe cooking. These are really good times to just consider and think and just reflect on what you have read, reflect on the arguments, and it might be during these times that you kind of have an idea, you start to reflect and understand what your own view might be, and sometimes it might take time. just sitting with and familiarizing yourself with the different views. But it's really important to try to reach a particular view and justify it. So that's a poor approach to nuance. Now, here's a good approach, although an approach that is still lacking some element of nuance. Here, the writer presents a strong central argument, which is good. The writer engages with opposing arguments, but the writer does not acknowledge the strengths in the opposing arguments where they appear. Additionally, the writer may misrepresent opposing arguments or ignore the strongest. So this is where you have a load of research that when you're choosing what you might want to include in your argument, you're kind of picking things to support a hypothesis that you have kind of already decided. And this is part of legal writing. This is part of your kind of research, your dissertation. You're kind of testing a hypothesis. You're considering what type of research is going to kind of inform your own response. But you need to be able to identify that there are opposing views and not misrepresent them to in kind of support or shy away from them because you are wanting to support a particular argument. You don't want to be dogmatic in your views. In order to show that you have a very excellent understanding of a legal topic, you can show and demonstrate that you are aware that this issue has nuance, that this issue is not necessarily black and white. And the way you do that is engaging with these opposing arguments where they appear in the relevant sections on your topic. So finally, we have an excellent approach. And this is where the writer argues strongly for one perspective, but acknowledges the strengths in the opposing position and the ambiguities and the uncertainties in their own. Opposing arguments are considered fairly and not strawmanned. And it's important to note that rarely in academic debates is one side completely and obviously correct and the other completely and obviously wrong, which is something I've touched on already. So it's important to kind of acknowledge the ambiguities in a topic, but also the range of legitimate and reasonable opinions within the topic, which will add nuance and make your argument more convincing. Moving on now to the conclusion, I have on the screen an example of a conclusion that hits kind of three clear aspects of what you should be aiming for, which is a recap of the points made, a clear statement of your central argument, and an ending on a general forward-looking note. So I invite you now to pause and have a read of this example and consider, based on the highlighting, what parts of the conclusion meet these aspects. Now moving on to practical tips for starting and continuing to write, which sometimes can be the hardest part of legal writing. So you might be thinking where to start. The introduction, maybe? Some academics suggest writing the introduction at the very end. But this depends really on your approach. If you've got a good plan and if you have conducted a lot of research, then the introduction can be a very helpful place to start. This is because it's going to force you to clarify your argument and state it with precision. The way I normally approach this is by writing a rough introduction at the start, knowing that this introduction is probably going to change and I will be coming back to it after I've finished the rest of my writing. I find it useful to define my terms, define my argument, have it clear there so I can check and go back onto it, but also being aware that it's probably going to be amenable to change. And that helps to kind of balance between wanting to structure your argument, be clear of the structure of your argument before you write, but also ensuring that your introduction covers everything that you have included in your writing, because a piece of writing will take, in some regards, its own form, and going back to your introduction will enable you to be flexible to that. In your Word document, you can replicate the structure of your plan through the headings feature, so it's really, really clear. And If you're facing a mental block for writing a particular section, then don't be afraid to just leave it for a couple of days and jump to a different section and then start writing that section instead. And this can be particularly helpful if you suddenly have a good idea of something to write in a later section. And don't be afraid to go back and do more research if you are unsure of what to write because of a lack of understanding of the law or knowledge of the arguments made in secondary literature. So you can add in kind of different bits of research when you need to really shape your argument more. If you might identify as you're writing certain holes in your argument or holes in your authorities that you need to kind of pad in and supplement with further works. Don't be afraid to also have a look at examples. So your aim is basically to write a journal article here in your dissertation. This is what you should really be modeling the piece of writing on. And in order to do that, think about a particular legal journal article that you found interesting, which is relevant to your dissertation topic. You might want to consider how the writer writes in terms of style and form. How does the author structure their article? What sort of things does the author say in the introduction? All of these are potential approaches you can consider replicating in your own essay. Obviously, you're all very kind of aware of plagiarism, but using an article to guide and to inspire in terms of more general aspects of style, form, introductions, conclusions, it can be a really, really useful kind of tool to have to almost keep checking back and seeing whether your piece of writing is reflecting that level of kind of journal or legal writing. And reference as you go along. So footnotes and bibliography. It can be really tempting not to do this, but it just creates so much work at the end. And towards the end of this deadline, you want to be proofreading and finalizing. If you identify or flag up potential issue with a footnote, it can just add on hours, and which from my experience can be extremely stressful. There are certain kind of platforms that you can use now to help you with footnoting and help you with referencing. Or if you're doing it manually, a good way to approach it is by just having a Word document, and before you start writing, turning all of your resources into a footnote that complies with whatever style you're using. So turning each reference into that format, and then in terms of your bibliography and your footnotes, and when you start footnoting, you can just pull the article from there and add it into your footnote. And finally, carefully plan and schedule your time for writing in your calendar, aiming to leave a few days or a week to proofread before the deadline. Now moving on to how to approach clear expression in legal writing. So I mentioned already the use of headings and subheadings throughout the essay. Also, trying to keep sentences short wherever possible, because this enhances readability. Sometimes you might not be able to avoid using a very long sentence. However, keeping sentences short, snappy, if you can explain your point in the fewer words, it shows that you really understand the topic, because you're able to really get to the point of what you're trying to say. And it also helps and assists the reader in writing. Attempting to write in the active voice rather than the passive voice. So, for example, saying the man kicked the ball rather than the ball was kicked by the man. So the active there is the man doing the action of kicking. It just helps you to be more direct in your writing. Then ensuring correct spelling and grammar. Things like Supreme Court and Act of Parliament being capitalised, using judgment with no E. In formal writing, never use the apostrophised version of words. For example, always use you are rather than your, etc. It might be helpful to have a separate document, which we do here at the Law Commission, which is it's called a consistency guide. And as you're starting to write and as you're kind of coming across certain errors that you are making, you're identifying as you're writing, or certain decisions that you've made for consistency based on capitalization or based on how you're going to define a certain topic, then you can add this into your consistency guide and make sure, and then you can check and do a kind of a control F to check if you have made any errors based on these kind of flagged potential issues or potential points that you want to follow for consistency. Then italicizing case names and Latin terms. Where possible, writing in plain language, which is accessible to all readers. The exception is where specific legal term or language would be more appropriate and precise, but it's not about being as kind of complex in your use of language. It's about being clear and about being concise. The legal issue that you're talking about will be complex, and if you're able to break those complex issues down into simple, clear and structured language, then it shows you have a really high understanding of that complexity because you can break it down into its kind of key components. And then use and embed quotes from primary and secondary sources. However, when you do so, making sure that your voice remains clear by overtly distinguishing your own views or your arguments from those made by the academics that you cite. So this goes back to this point of having a clear argument and having a clear narrative voice. And in order to distinguish your views, it's really important, as I've said earlier, about having a real understanding of your position on the legal topic, which will be clear from your introduction. Now, proofreading. Top tip for proofreading is printing out a physical paper copy of your dissertation. Proofread this physical copy with a coloured pen, noting mistakes, crossing out unnecessary words and sentences, and writing improvement ideas regarding structure and content in the margins. I think that looking at a paper copy of your work strangely helps to provide a sense of perspective, just taking it off the screen, seeing it on paper, going through it with a red pen. I find it also really helps checking your structure, checking how everything fits together and flicking back and forth throughout your piece of writing. Word count. Don't worry about going over the word count during the writing process. This will be cut down eventually, although if you are feeling that you are going quite far over the word count, assessing your kind of timeline for writing and extending the period of time at the end for editing and cutting words down. But the process of reducing the word count will help you improve your writing by forcing you to be more concise. So it can actually be quite useful to have to go through that process. And you might have to be quite brutal with what you want to be cutting out from your essay. It might mean there is a particular section in your writing that you really like, or that you really enjoyed writing, or you think is a really good point, but actually on reflection, it doesn't have a place in your whole dissertation, or it kind of isn't as relevant as you initially thought. Don't just keep it in, just have to be brutal and remove it. Just assessing and looking through every single kind of sentence that you're writing and questioning whether it has a place related to your argument. What does it add to your argument? And then editing structure. So initially during the writing process, just focus on getting the words down on the page. Once you have completed a first draft, then you can go about editing the structure and order of your essay, which will be significantly easier. Take a break after finishing a first draft of the dissertation before attempting to proofread it, and return with fresh eyes. Or if you've finished writing one section of your dissertation, move on to another section, start writing it, and then after you finish that section, go back and proofread the section before. It's really important to just step out and have a break from what you have written, so your brain is not playing tricks on you whilst you're editing. And finally, reading your essay out loud. It might seem quite silly, but reading your essay out loud can be quite a good way of checking that you're not using really long phrases and you're not kind of expanding on parts of your argument that you don't need to expand on. So if as you're reading out your essay, you're kind of running out of breath, or the words just aren't really making as much sense when they're spoken, then that can signpost you to a part that needs to be edited. Okay, and finally, we have on the board some practical dissertation tips from research assistants at the Law Commission. And I invite you to just have a read of these practical tips, make a note of them, take a photo if you like, and keep them in your brain whilst you are approaching your dissertation, as they might be useful in helping you approach your topic. Thank you very much, and good luck in completing your dissertations.